What's going on, people? If you're here, if you're not here, what's going on, my people? What's up, Firekeeper? Gonna get this going, man. We're gonna talk about a little non-judicial foreclosures. That's what we're about to do. First, let's get some music in. Uh,
wonder where he's been, watching over, immersed in toxins to stay sober. Seeing all these deaths, viewing all these bodies, dog eat dog world, it's my turn, everybody gather round and listen, hear the sound, time to stand ground. If you got some melanin, telling you what's up, I reach down deep in my guts, trying to get that vibe through without giving a touch. But inspiration goes a long way, when it comes from you, they know the difference, because when it hits, you know it stays, not like leeches, the thongs and ass put on Caribbean beaches. Just wanna get in, get down and reaching your mind. Do you like how I'm teaching? If not, move on, cause only to the chosen who I'm speaking. African, Latin, Asian, all of them moving. From Project Brothers on the blocks, Brazilians and Puerto Ricans. My mission today is how we do it all day. Rest in peace, my.
How can it be? She wrote a number down, it's here in front of me. Don't understand. She must have told me a lie. I wonder why knew me, but I can see really a lie. I wonder why knew me, but I can see really.
The official adventures.
Yep. Infinite ways. Yep. Let me turn the page on them real quick. It's that smooth shit right here. Smooth it out now. Come on. Come on. Yeah. Come on. Come on. How we do it? How we do it? Say it's infinite ways. Say what? How we do it?
How can it be?
How could it be? Once again, y'all smooth. Sensation, check it. The sensation brings me to the right location. No rat racing, cruise control debating. What's the next move? What's the next move? Y'all smooth, get back, sit in and stay tuned. Living life to the fullest. The full-ish, push the spit out and break north with no resistance. Efficient, cause I'm chilling in the Pisces constellation. Where we stay top of Leo, that's my protection. Since
The sun is in the sky, but I refuse to smile.
All right, enough playing around. Let's get busy. We're gonna go into these non-judicial foreclosures and lawful detainers, how they work together. Um, let's see here. Yeah. All right. What's up, people? Hopefully everybody can hear me. We're gonna go into these unlawful detainers, foreclosures, how these people do some of these different type of things. Let's go here. I was just playing around with this music. Oh, get out of here. All right, let's drop that. No, let's not drop that. Let's keep that up. All right. So in California and in a lot of states, they have what you call a non-judicial foreclosure state. And what I'm gonna do right now is just share this screen real quick. Let's go back here. We're gonna share the whole screen. What are non-judicial foreclosures? Just so we get a quick look at what that is. All right. So as you see right here, judicial versus non-judicial foreclosures. All right. So as you see, it says if a lender proceeds with a foreclosure on your home, it may be able to choose between a judicial and a non-judicial foreclosure. Essentially, a judicial foreclosure means that the lender goes to court to get a judgment foreclose on your home, while a non-judicial foreclosure means that the lender does not need to go to court. Every state allows the lender to get a judicial foreclosure, but not every state provides procedures for a non-judicial foreclosure. The difference between these processes can have an impact on how a homeowner makes a defense to a foreclosure, if any applies. Now, right here, so every state allows a lender to get a judicial foreclosure, but not every state provides procedures for a non-judicial foreclosure. So even in California, the banks can go to court to get a judicial order to foreclose on real property, but they don't. They use the non-judicial foreclosure process. So what we're going to do now is what are the steps in the non-judicial foreclosure process? Okay, 7 steps. The lender may be required to send a notice of default and a notice of sale. Loss mitigation required under federal law. The period for publication before a foreclosure sale. The auction, the right of redemption, and eviction. Deficiency lawsuits. So this right here, see, this is like websites like this where they're not telling the exact truth in the process, right? Because if you're a homeowner, how can you be evicted as a tenant? Question. That's a question. That's a major question. Right. So you might imagine after a foreclosure sale, the borrower would have to leave the foreclosed property immediately. But that's usually not true. Of course, the former owner might choose to leave the property after the foreclosure sale. Choose, right? Choose, not forced, but choose to leave. They could also choose to leave earlier than that if they don't leave voluntarily. Voluntarily. The buyer will typically have to formally evict you. They can't simply put the previous owner's belongings out on the street and change the locks. The process varies depending on state law. It generally starts with serving notice on the occupant. So you see right here, you went from owner to occupant. The notice demands that they leave the property. The notice includes a deadline, and in some states, it can be quite short. For example, California law allows the occupant just 3 business days to move out, but that's just the first step. If the occupant doesn't leave by the deadline, the new owner will generally have to file an eviction proceeding in court. Now, what sense does that make? Everything I've read, what sense does that make? You went from choose to leave, occupant, you went from choose to leave, right? Choose to leave. And then you say there's a foreclosure sale, and then they notify you that there was a foreclosure sale, and now you got to leave. And if you don't leave, I'm gonna have to go evict you, the previous owner. this new so-called owner who bought the house at a foreclosure auction, how are they now landlord and you are tenant? Now I'm gonna show you something in a trustee's deed upon sale, where in the foreclosure sale they actually state in the foreclosure sale that you sold it, the previous owner. So just look at the jargon in this, right? See, if I had time, websites like this, I would find them and sue them for constructive fraud, because you might be an attorney firm and you're putting out disinformation. You can evict somebody without having a lease agreement. Anybody answer me this. What is the main thing that you need to file a landlord tenant suit for eviction? You can put that in the chat if you want. What's the number one thing and the only thing that you need to show that you have the right to sue in a landlord tenant jurisdiction? Okay. So anyway, enough about that. So, you know, the jargon is kind of crazy. How these people actually um, put themselves in position as if they have the right to do anything. So, so that's cool. That's cool. I'm gonna get this out anyway. They can watch it later. um, so I'm gonna pull up some of this stuff right here and show you about these foreclosures. And I'm gonna show you the documents, right? I'm gonna show you the documents. I'm pulling it up right now, and then I'll share the screen. All right. So if you see right here, right, this is a notice of default. This is a notice of default. And this is in California. If you see right here, this is the declaration of mortgage servicer pursuant to Civil Code 2923.55C. See, I took out all that information right there, but it has four boxes you can check, right? There are four boxes you can check. Let's go through each of them. It says the undersigned declares that, which is this one, the mortgage servicer has contacted the borrower pursuant to California Civil Code subsection 2923.55B2 to assess the borrower's financial situation and explore options for the borrower to avoid foreclosure. 30 days or more have passed since the contact was made. So that didn't happen. And here's the key thing here. Mortgage servicer. Doesn't say mortgage lender. Doesn't say mortgage creditor. It says mortgage servicer. So they're servicing the mortgage. Right. Two, the mortgage servicers has exercised due diligence to contact the borrower pursuant to California 2923.55F, but was unable to contact the borrower to assess the borrower's financial situation and explore options for the borrower to avoid foreclosure. That was not checked. No contact was required by mortgage servicer because the individual did not meet the definition of a borrower pursuant to subdivision C of section 2920.5. That wasn't checked. Now, this one was checked. There's no contact was made with the borrower pursuant to California Civil Code 2923.55 because the above reference loan is not secured by a first lien mortgage or deed of trust that secures a loan or that encumbers real property described in California Civil Code 2924.15. Now we're going to look up these codes here. So what they said is they did make contact with the alleged borrower for these specific reasons: that the loan is not secured by a lien, first lien mortgage. So that means no mortgage on it. So how they a mortgage servicer or deed of trust, right? That you need to have, right? When you buy property, they actually in the double close or simultaneous close process, they actually um, assign and transfer the instrument, the note, over to a real estate investment trust or an investment company that takes it over. And then they use that deed of trust as it is because it's a security instrument, right? But it says right here, first lien or deed of trust that secures a loan, right? So it says right here that the deed of trust secures a loan. And also the above reference loan is not encumbering real property. So if these are the cases, then what you got right here is what you consider to be an unsecured loan. It's not secured. It's unsecured. Why is it unsecured? The reason why it's unsecured is because now the note and mortgage has been separated and paid off. As soon as you get a second borrower, or I should say a second so-called mortgage servicer, that loan has been paid off. What you need to do is, if you have mortgages or if you had a mortgage, go back and look at your paperwork, because I guarantee you who you started, which the names on your deed of trust didn't finish servicing that loan. They didn't finish servicing that loan. It always went to somebody else. And then what happens is that loan number that you had in the beginning, it turned into a different loan number. That's how you know the previous account with the previous so-called lender that you mortgage servicer actually that you actually did the initial transaction with has been paid off. Because if it wasn't paid off, why is there a whole separate loan account number? It's really not a loan number. It's just an account number that they're using. Go back and look. Now, this is a notice of default. Now I'm gonna stop sharing, and then I'm gonna pull up this open. Uh, picture. We're gonna pull up a notice of trustee sale. And we're just gonna go to the second page. Yeah, this is kind of uh, well, might be hard to read, but this is what you call notice to potential bidders, right? And then we're going to check these codes out, so we'll reference them and show that this is what it is. Um, all right, this is the notice to potential bidders. Here's what it says, and just remember what I just read to you in the notice of default. If you are considering bidding on this property, you should understand that there are risks involved in bidding at a trustee auction. You will be bidding on a lien, not on the property itself. So if you're not bidding on the property, then how is this article saying what it just said? That article I just read on the internet. How are they saying that you actually bought the house, you bought the property, and you can actually go to you can go to court and then seek an eviction as a landlord and the owner being the tenant. But right here, it is saying what it just said. What it said. It said you are bidding on a lien, not on the property itself. Now let me do you one better. We're about to go to the code. We're about to go to the code. Uh, we're about to go to the code. And see that? This was the article we was reading. That's what the article was reading. You might imagine that after a foreclosure sale, the borrower would have to leave the foreclosed property immediately, but that's usually not true. See, this is constructive fraud. This is misinformation and disinformation. Bottom line. See, auction. See that? All right, let's go here. All right. I'm not even looking it up. I'm about to show you right now. This is how I know how I'm, I do this. This is California Civil Code 2924 FB 8A. As you can see, this is California Civil Code 2924F. We go to B, 8A. This took in effect in 2012. Why did it come in effect 2012? What was happening at that time? A lot of people was getting their properties foreclosed on. That's why after the pandemic, it was the same thing that happened again 8 years later, right? So it says on or after April 1st, 2012, if the deed of trust or mortgage containing a power of sale is secured by real property containing from 1 to 4 single family residences, the notice of sale shall certainly substantially the notice of sale shall contain substantially the following language. in addition to the language required pursuant to paragraphs 1 to 7 inclusive, right? And as you see, as I read on the notice of default, right? When I read on the notice of default, it said that it is not secured by real property. The lien is not secured by real property, a deed of trust or a mortgage. So it says right here, if the deed of trust or mortgage containing a power of sale is secured by real property. Let's go back here. Let's go back here. I want to remind you of this. I want you to listen to this closely. I want you to listen to this closely. Right here. What does it say? No contact was made with the borrower pursuant to California Civil Code 2923.55 because the above reference loan is not secured by a first lien mortgage or deed of trust that secures a loan or that encumbers real property. Here we go. On and after April 1st, 2012, if the deed of trust or mortgage containing a power of sale is secured by real property. So these people are still, as I showed you this notice of default that I showed you on page 4, these people actually filed the notice of trustee sale because this is dealing with notice of trustee sales, right? Just so we clear, right? So as using this section, property means real property or leasehold therein, except as provided in divisions before any sale of property can be made under the power of sale contained in any deed of trust or mortgage, right? So you see right here, this is dealing with sale of property. So right here in the notice of default, it already said that it didn't fall into this category. So why are we getting the notice of trustee sale? How you put out a notice of trustee sale when the property, as stated in the notice of default, is just a notice of default. It was supposed to stop right there. Remember, when you're doing the notice of defaults, when you get a notice of default, make sure you read this disclosure line. They got to have this disclosure. This declaration. Make sure you have this. Read this. If it's this right here, you could take a deep breath and say, okay, now we know from this point forward, a lien is being sold. And then we could jump ahead of the game. So that's just giving you that tidbit. So just remember 2924 FB 8A 2923.55 2924.15. Now, let's get over here. Let's read the rest of it. Just for shits and giggles. Notice to potential bidders, if you are considering bidding on this property, you should understand that there are risks involved in bidding at a trustee auction. You will be bidding on a lien, not the property itself. So listen, even if one of these other ones was checked, let's say number 1 was checked, you're still bidding on a lien. You're still bidding on the lien, not the property itself. Doesn't matter. Even if you fall under these things where everything is straight. Not like the one I just showed you. If everything is straight, you're still bidding on the lien. Placing the highest bid at a trustee auction, right here, does not automatically entitle you to free and clear ownership of the property. Now, what is the property? Is it the movable land or is it the movable structure on top? Land is immovable. At no point in time in this, they're talking about land. Land is never mentioned. They're only talking about property. They don't even say real property. There's 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 different things. There's personal property, there's real property, there's other types of property. You really have to play semantics with this thing because all these words mean something. So, like, in for instance, with this other thing, some of these might have a second or a junior lien, a little equity line. Basically, it says right here, you should also be aware that the lien being auctioned off may be a junior lien. If you are the highest bidder at the auction, you are or may be responsible for paying off all liens senior to the lien being auctioned off before you can receive clear title to the property. See, but all you're doing is getting in first position. Now, I could show you something else, but that'll be too much editing and stuff like that. But it showed that I saw that when I pulled the records, I had somebody pull the property records. Basically, what it was saying was that that new thing that was supposed to have been foreclosed on was just a first lien position in the records, in the property title record. So, but that's what's happening. So you're looking at a whole different um, um, act or show being done, and based on the disclosure is not being put forth on what is actually going on, and that's really not, being under stress, not knowing what's going on. You, you're stressing, you're worried, you're thinking everything is, right and exact. This is law what they're doing. I'm showing you right now. It's not. How are you going to take some? How are you going to be able to take real property, record it without a judge? But you know who started the non-judicial process? California. Now, let's go to 29, 24, uh, 2924.15. Okay. This is first lien mortgages or deeds of trust secured by owner occupied residential real property. Right. So these are first lien mortgages or deeds of trust. So you see it says or. So you pretty much kind of run parallel with each other. It's kind of the same thing, however you want to, in different situations. So it says right here, unless otherwise provided, paragraph 5, subdivision A of section 2924 and sections 2923.5, 0.55, 0.6, 0.7, so on and so forth, shall apply only to a first lien mortgage or deed of trust that meets either of the following conditions. The first lien mortgage or deed of trust is secured by owner occupied residential real property containing no more than 4 dwelling units. For purpose of this paragraph, owner occupied means that the property is the principal residence of the borrower and is security for a loan made for personal, family, or household purposes. I'm gonna get back to these two in a second. The first lien mortgage or deed of trust is secured by, okay, so this right, okay, is secured. Two, is secured by that is occupied by tenants. All right. So it has to The first lien mortgage, it has to be secured by owner occupied residential real property. If it's not secured, then they can't move forward. They can put a notice of default in there based on, let's say, a debt that's owed and hasn't been paid, and they can put a lien. Yeah, they can lien on it and then create the lien in the county. They can file it or whatever, file a UCC financing statement if they want, but they don't do that. They actually start off with the notice of default and then they run with this whole other things that they do. Right? Number one, they do a corporate assignment of deed of trust, meaning they actually create documents that is considered to be coming from what would be considered the actual so-called lender that you open up the transaction with. And then they're saying they take that name as the beneficiary and is assigning it to this new bank or whoever else is coming to so-called service the loan. And then after that, they utilize these companies uh, that act like foreclosure trustees. Now, when I come to find out that the majority of these are ran by attorney firms, and they're operating as self-appointed trustees or substituted trustees of that deed of trust that they're trying to foreclose on. Right? All of this is being done without the approval of the trustor. Now, B, owner occupied means that the property is the principal residence of the borrower and is security for a loan made for personal, family, or household purposes. Now, this is important. Anything that you provide that is utilized for your own personal, family, and household purposes, it's not business. This is where the things get mixed up because those three things keep you out of the income bracket. Everything is really after that is supposed to be recoupable because of your investment into the system, utilizing some of these banks that are subject to the Federal Reserve, the FDIC, the NCUA, and but it's being flipped back over on top, where now you become liable for all the debts, all the taxes, and then the banks are getting nothing but a donation, and it's a gift. Remember, I explained to you about a gift. So you're seeing it right here. Now, this is California, talking about California, but there's other states that got non-judicial foreclosure processes as well. Now, let's pull up 29, 23, 55. Okay, so it says a mortgage servicer, mortgagee, trustee, beneficiary, authorization shall not record a notice of default pursuant to section 2924 until all of the following. Remember when I read 2924 F B 8 when it said has to be secured. I showed you 2924. Let me pull up these other ones real quick. All right. So as we saw right here, 2924.15, first layer of deed of trust, secured by owner-occupied residential real property containing no more than four dwelling units. As I read the notice of default in the beginning, doesn't fit that. 2924 F8 FB8A, if the deed of trust or mortgage containing the power of sale is secured by real property containing from one to four single family residences. All right. No notice of default. So that no notice of sale should be made here either. So we went all the way past that, but no notice of default. Pursuant to section 2924 until all of the following. The mortgage servicer has satisfied the requirements of paragraph 1 of subdivision B. Nope. Either 30 days after initial contact is made. Nope. That box wasn't checked. The mortgage servicer complies with nope. If the borrower has provided a complete application as defined, nope. B1, as specified, a mortgage servicer shall send the following information in writing to the borrower. They did that. Well, they didn't do that. B, a statement of the borrower may request the following. Statement of the borrower may be a statement that the borrower may request the following. A copy of the borrower's promissory note. They didn't do that. Or other evidence of indebtedness. Copy of the borrower's deed of trust or mortgage. Didn't do that. Copy of any assignment, if applicable, of the borrower's mortgage or deed of trust required to demonstrate the right of the mortgage servicer to foreclose. Now that's where the fraud comes in. Now, if once you get into that, right, you're gonna have to put some money into this. I mean, even if you're good, you're paying your mortgage, you straight. Don't just go along. I'm just showing you could just go back and do what you normally do, but don't act like you haven't been told. But if you have money, you put some money to the side and go hire you an auditor. They got plenty of mortgage and security auditors out there that will audit those reports and give you a full breakdown of what's going on with that account. They'll even show you, even if the contract, the deed of trust is good, what's happening to it, where to go, what's being done to it, so on and so forth. So, but this is what's going on in California. They're filing things, right? Just like this article I just put up. They're just filing things, and the county recorder's office is allowing it to go through, knowing that it's not supposed to go through. They're not fact checking these things. They're allowing these companies to file these things, and they know they're faulty. Just like this right here. See this girl. She's an attorney. Me, yeah, we'll probably send her a message and tell her to remove it because she's lying. Yeah, I think I might do that. But anyway, so we have this information right here, but peep this though, right? When you get to the point where it gets past, let's say the foreclosure sale happens and so on and so forth, when you look at it, it's going to actually state that you sold it, or the foreclosure trustee sale company, as the new self-implemented substitution of trustee document projecting, is stating that you authorized it. All right, so let's go here. We're about to pull this up. Yeah. So we're gonna bring this up real quick. Let me go ahead and do some editing real quick. Let me redact some of this information. Uh, so yeah, we're gonna get this going. I mean, it's interesting how they constructively do these things. Um, I'll leave that company there. I don't mind showing that. Y'all know who's actually doing these things, right? And bam. So we're gonna get this right. Uh, where we at? Where we at? What else? What else? What else? Okay, let's take that out. Bear with me. Bear with me. We got to get all this stuff out of here. Okay, let's get the money out. All right. So, so as you see right here, right, this is what you would consider to be a trustee's deed upon sale. This is a trustee's deed upon sale. This is what happens after the foreclosure sale takes place. Now, keep in mind, go back and listen to, go back and listen to, not listen, but just go back and just keep in your mind what the codes I read you. California Civil Code 2924, uh, 0.15, 2923.55, 2924 FB8A. That deals with the notice of default and deals with the notice of trustee sale. Two of the main things that are important because they have to follow the rules. So, so right here says the undersigned. Oh, that's a little more. Oh, that's too big. The undersigned grantor declares the grantee herein is the foreclosing beneficiary. The amount of the unpaid debt together with cost was, there's the money, the amount paid by the grantee at the trustee's sale was, we're going to take this line by line. The amount of the unpaid debt together with cost was that amount. The amount paid by the grantee at the trustee sale was that. So in this situation, none of that happened. This ended up being what you would call a REO, right? Which is a real estate owned, bank owned property. It just goes back to the bank. Nobody bought it. Foreclosure sale was stopped. So they did it, said it reverted back to the beneficiary. And then basically after that, the bank bought it. And they're saying the bank bought it at the trustee sale, which is absolutely false, as was told to me based on what they did. Now, this you guys look up this company right here, Quality Loan Service Corporation. Um, what these people found out was that Quality Loan Service Corporation was actually ran by an attorney firm. Same names, did a whole check on them, same names, directors, everybody. You see, which is a violation of Fair Debt Collection Practices Act. Attorneys shall not operate as debt collectors. It's under Public Law 93-217, something like that. And it's under the Fair Debt Collection Practices Act or Title 15 USC 1692 E, impersonations. And then K, you got K and I and all that type of stuff. But as you see right here, it says Quality Loan Service Corporation as trustee, right? How they become trustee. What happens is that JP Morgan Chase Bank actually put them as they created this substitution of trustee document. That's another part of the non-judicial foreclosure. You have a notice of default, you have a corporate assignment of deed of trust, you have a substitution of trustee, you have a notice of trustee sale, and then this document comes after the fact. JP Morgan Chase Bank wasn't the initial servicer of the loan at the initial transaction. They became a debt buyer after the bank went into bankruptcy. Um, from that perspective, the corporate assignment of deed of trust now becomes null and void because JP Morgan Chase was not the beneficiary in the matter. And at that time, the date of when it's being signed, this is how detailed it has to be. The bank went bankrupt back in 2008. How are you doing a corporate assignment deed of trust in 2019? And then you're saying that you're saying that the bank is actually uh, doing the assignment. So, so it says J.P. Morgan Chase Bank, herein called grantee, but without covenant or warranty, expressed or implied, all right, title, and interest conveyed to and now held by it as trustee under the deed of trust and to the property situated in the county. So the Quality Service Corporation is granting and conveying as trustee of a trust, this deed of trust. This is showing you that a deed of trust is a trust relationship that we have no control over because we haven't set the terms of the trust. The trust and the will go hand in hand. It's your will that you're willing it to be this way as the trustor, right? So here it is. So it says they grant and convey to J.P. Morgan. Herein called grantee, but without covenant or warranty. So there's no warranty on it. There's no covenant on it. These words are very powerful. Look them up. Expressed or implied? Is it expressed or implied? Which one is it? You see how vague this is? This is very vague. This is very vague. We don't know what it is. It's not solid at all. But the county recorder's office is taking this as if it's law, or if it's valid, or if it's perfect. It's very imperfect, but they take it. And then when the people try to do the same thing to affect it and make it go back right to where it is, they reject it. And then they open their mouth and they say, oh, well, you sold it to them. Well, I'm saying I didn't. Show me the documents that they put in with this thing. No, we can't do that. That's private information. How is it private? And this is a public setting. The county recorder's office is a public benefit for the people to register their instruments, just like a bank. So, express or implied. Expressed is you spitting it out. It's just like it's not written. It's just expressed. Implied is implying the details of the language that's in here. So it's implied that Quality Loans Service Corporation is the trustee, or it's been expressed that they're the trustee, and that JP Morgan Chase Bank National Association is the grantee. That it was done without covenant or warranty, and that all right, title, and interest be conveyed to and now held by it as trustee under the deed of trust and to the property. All this is implied or expressed. Somebody said it. Who said it? Let's get to the next line. The conveyance is made in compliance with the terms and provisions of the deed of trust executed by blah, blah, blah. That's the name as trustor. So it's actually saying that the trustor is the one that made this express or implied agreement or order or direction. And we'll get to this donor again. Every time I go live, I'm gonna bring up this donor-donee relationship in regards to this, because they're actually saying that you did it. And they're using an instrument that has nothing to do with JP Morgan. It has to do with the other company that went bankrupt. But as you see in the notice of default, it showed that nothing was no lien was encumbering the real property. So remember, I'm going into something else. Repeat 29, 23, 55, 29, 24F, 29, 24.15. Keep that in your head while I'm talking about this. All this is being done after they have admitted in writing, recorded in the county, that the property was not encumbered by any lien. And that they knew when they was purchasing at the foreclosure sale under 2924F BAA that when you was making a property, you was only buying a lien, not the property itself. And then they got the nerve to say, under the authority and powers vested in the trustee, designated in the deed of trust, or as the duly appointed trustee, the fault having occurred under the deed of trust pursuant to the notice of breach and election to sell. Now, all this is being done under these things. After all this, they file this. Let me stop sharing real quick. Let me get on this real quick. I need to pull up another document so it could be okay. Edit. Oh, close that. Let me edit this real quick. Take these numbers out. Hide the property address. Let's go back to the let me share screen again. Look right here. Look right here. It says under the deed of trust pursuant to the notice of breach and election to sell under the deed of trust. This says notice of default and election to sell under deed of trust. See, this is where they get you in pickles. There is a summary of the information in this document attached to a copy provided to the mortgagor or trustor. 2923.3. This is how you know that this document is faulty at best. This is fraud. This is willful intent, willful fraud, actual fraud. This is forgeries. It's all different type of things you got going on here. But they know these documents are not valid documents. These are not valid documents because these documents are considered to be prejudicial administrative type documents. So if you do go to court, you have to use these documents as evidence. Now, this is 3 pages. If I actually scroll up, you'll see this document was used in a court case as an exhibit. Now, what is missing here is that this document is actually 3 pages. It's missing the notary page. This document was submitted into evidence as an exhibit, missing a page. This document was also used as an exhibit and as a rental agreement. Right? So just know what's going on here in California. Now, as you see all through this thing, it's talking about property, 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 right? It's talking about property, 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 property. I'm about to pull up something else. Let me pull up something else for you real quick. Hmm. And this is what you guys need to know. if you got your documents, in uh if you got your documents from when you did your closing, right? All your escrow documents, your preliminary title report, pull that out. Pull out all your documents and go through it, right? Pull up all your documents and go through it. I'm gonna redact this real quick. Get these names up out of here. No, undo. Hmm, hold on. Did I do that right? No. All right, so let's go here. Now, you see right here, this is important. Right here, right here. 1, 3. Right. The estate or interest in the land hereinafter described or referred to covered by this report is a fee. Title to said estate or interest at the date hereof is vested in, and that's the name. So as you see, it's talking about land. And none of these documents, none of these codes is talking about land. They're talking about property. What is the property? The property is what you would consider connected with the situs address, is what the proper term is. It's called a situs address, or they say commonly known as address. That is your public, or what they will call your municipality and your tax. That's why you get taxed. And they also have a parcel number, right? So as you see, this is the Fidelity National Title Company preliminary title report. You will have that in your records. Now, the other thing you need to pull up is you need to pull out the deed of trust, the contracts that you actually pulled, and then go to the county recorder's office and get a copy of the deed of trust that you have in front of you. It's going to look totally different. Why? Because the one you have is going to have certain signatures, your signatures on it, but nobody else's. Once you get that, it's going to be a totally different document. That is not the document you ever received. Number 3, the grant deed, the warranty deed, or the limited warranty deed, however they got it, in whatever state. You never received the original. Who has it? That's who has it. Nobody never thinks about these things. Maybe in some states you got your original, but most of the time, nobody has the original. They think they do, but they do not. Go get that. When you pull your preliminary title report, you get the information on the deed of trust, get those things and take a look at them. Go get it. Go find the original deed of trust. Where is it at? I need to see my wet ink signature. Why doesn't this match my records? You won't be able to get any answers because the person that you actually did the transaction with is gone. You're paying somebody else under a new account number. Bet me on that. I'm about to put my website in the chat. I'm about to show you the website, show you where to click the donate button because I'm giving you gold and silver. not FRNs. Number four, contact these people. Contact them. Ask them, where's these documents? Why is my documents looking like this and it's looking like that over there in the recordings? What happened? Where's my original grant deed that the previous owner gave me? That's gold right there. It says who the owner is. The schedule right here. Say who's the owner is of the land. You own the land in a fee. Now, let's go to let's go look up what a fee is real quick. Let's go look up what a fee is. Let's go show what a fee is. Let's go pull up what a fee is. Uh-huh. Yeah, we're gonna get to it. Let's go here. My bad, y'all. But we got it. All right, here we go. Here we go. Fee. A charge fixed by law for service of public officers or for use. That's not it. So right here, it states, right? Okay, let's go back here. Let me stop sharing because I think I only shared half the screen. Let me share the whole thing. Okay, so right here, as we see, when we looked at the preliminary title report, right? So it says the estate or interest in the land hereinafter described or referred to covered by this report is a fee, right? So we're dealing with estates here. So an estate of inheritance without condition, right? An estate of inheritance without condition, belonging to the owner and alienable by him or transmissible to his heirs absolutely and simply, and is an absolute estate in perpetuity and the largest possible estate a man can have, being in fact allodial in its nature. Now we see, uh, let's see, I don't know if you guys still here. I see you, Root. What up? Papa Draco, what up? So as you see right here, you know, a lot of people, you guys might be familiar with Root. I know Root is, a lot of people talk about this allodial title. See, when you talk about, say, oh, you need to know how to get a allodial title. You need to know how to get a allodial title. You ain't got a allodial title. I'm saying, yes, you do. You got a allodial title already. You have an interest in the land, right? Based on the fact that you don't have a land patent on it. But for the most part, that grant deed is something that's being handed down, which you now become the steward of that land at that point. Once you have tilled the land and you've been on the land for 5 years in California, you automatically have what they would call adverse possession, outright possession, and boom. So, so right here, this is a case law, right? This is case law. And it says see also fee simple. Ordinarily, word fee or fee simple, right? So I'm just showing you it is the same thing. Fee or fee simple is applied to an estate in land. Boom. Boom. Right here. So that's what that means. It means the estate or interest in the land hereinafter described or referred to covered by this report is a fee. So if it's a fee, you have it in fee simple, meaning you have an estate in land. These documents don't mention land. This document don't mention land. This document don't mention land. We're gonna go back to it again. Right? This mentions real property. Now that can mean anything, but they have to define it. This document mentions property. This doesn't mention property at all, but it has the property description, the legal description in there. That's what I had covered. That's what I got blacked out. Oh, there go property right there. Boom. See? But this says land. That says land. Now we know what the definition is, right? So, but term is applicable to any kind of hereditament, hereditament, corporeal or incorporeal. Now let's see what this means. Hereditament. That's crazy word. Right? In common law, so it's a common law word, is any kind of property that can be inherited, right? So that land in fee simple that you have bought is now considered to be what they call hereditament, that is to be passed on to heirs. So it said corporeal or incorporeal hereditaments are such as affected the senses and may be seen and handled by the body. Incorporeal are not the subject of sensation, can neither be seen nor handled, are creatures of the mind and exist only in contemplation. An example of a corporeal hereditament is land held in freehold and in leasehold. So here we go. So this is what that's explaining. I had to get that clear because that was the words. So you see, as we're talking here, these documents we have up here, these documents is talking about property and this, borrower, that, and all that. While this right here is saying something totally different. Once you receive that and got that clean title, that free and clear title, that is now your land, the estate or interest in the land. Everything else on top, okay, cool, came with it. You could have told them, tear that down. I don't want that. I want the land. Right? So I'm just trying to show you what your documents are saying. So go get your documents and read them. Go call these people. Go ask them what's going on. Go back if you did lose a house. Go back and look and see what happened. See what was wrong. You might be able to have action after that. You see? So I'm just showing you these are documents. These are all the documents. These are key documents right here. And it's showing you right here. Just to recap, we started off with the notice of default, right? This is the first thing they file when they do this non-judicial foreclosure process. And then we can even go back to where we started at with this line, whatchamacallit. And like I said, I think I might just send her a message on this site and tell her to take it down for misinformation and disinformation, because that's a lie. As I just read, The lender may be required to send a notice of default and a notice of sale. We just looked at those. Loss mitigation, publication, the auction. We just went over that. What happens at the auction? Look at what she says. Like timelines and notice requirements, foreclosure auction procedures vary by state. Traditionally, foreclosure auctions have often been held on the courthouse steps of the county where the property is located. Recently, though, some states are moving toward online auctions. Why? Because these California is going through a lot of issues, even though people might not think so, is because these auctions are taking place on the court steps as if that um the often the lender will make the opening bid in the amount of the outstanding debt. This is known as a credit bid because the lender pays for the purchase without credit for the amount owed. The highest bidder takes the property, whether that's the lien holder or someone else. But in some states, the borrower still has a chance to reclaim the real estate after it has been sold. Now, as we see, what does this say? If you're considering bidding on this property lien, you should understand there are risks involved. You will be bidding on the lien, not on the property itself. So what is she saying? She's saying right here, highest bidder takes the property. Now that's a lie based on 2924 FB8A. Notice the potential bidders that has to be on the notice of trustee sale. And as we also see it right here on this notice of trustee sale. So she's lying. Now, as we see, if you haven't bought the property and the property isn't encumbered, how are you able to do an eviction as a landlord? Does that make sense? It doesn't make sense. So I'm just showing you this is the key to what is actually going on here. There's a lot of fraud going on here. How are they able to get these things through here? Everybody's supposed to know, the courts, the clerks, the judges, the attorneys. These people are supposed to know the law, but they're actually going against that. How are they able to get this through? They're getting this stuff pushed through. I'm gonna put the link in the chat, the Zoom link in the chat if anybody want to pop up. Uh, hold on real quick. Let me stop sharing. Copy invite link. There you go. There's the link. You guys want to pop up? Quick talk. We ain't gonna stay too much longer. I'm trying to curb myself, make sure I keep it at a timeline where it ain't super lengthy. And I wanna come back and I want to start chopping some of these things up. I pretty much hit all the points that we've been on, so that I want to get across. Um, but I have to do a lot of redacting and get this straight so I can actually show you some court cases and things like that, how these people moving. But I have to do some redacting. Like I said, this is wild out here in California, but this is what they're doing. So let's go back. There go me. All right. What's up? What up, man? What's happening? Hey, what's happening? What are you going on, Mike? All right. So as we looked at 29, 24, 15, this is California. We have 29, 23, 55. All these things right here have to do with these filings that I'm showing you. They have to meet these requirements in order to get these things filed, but they're filing them anyway, right? This is the key thing about this document right here, is that right here, as it says, expressed, right? Expressed or implied. So these things are going on based on prima facie evidence of what these people are saying. But if they know, right, if they actually read the document, the notice of default in the county, that could be challenged though. But all the other documents that's leading to a non-judicial, to a list, leading up to a sale of real property, that's the problem. We're gonna pull up this donor definition, right? Bam. Let's pull this on up. Um, bam. Okay. Let me go pull it up. We're gonna pull up this donor definition. Uh, we get this donor definition up, right? So we always gonna go here with it because everything you seen was talking about a trust, right? It's a trust relationship. Don't pick and choose when you want to use these words to your advantage or to be right. These words are these words. They don't change in any situation, right? So if the entity that actually supposed to have did this, right? This person who has interest in the land that is supposedly had as trustor gave authority to them. Where are the documents that allowed all this to happen? Where are the documents? Where do we have this agreement? Right here. Donor, the party conferring a power, one who makes a gift, one who creates a trust, he who gives lands or tenements to another entail. In Old English law, but he by whom lands were given to another, the party making a donatio. So, one who creates a trust. So, this deed of trust that they're talking about here, right? This one, whereas so designated in the deed of trust that was executed by this trustor. By definition, I am the donor, they are the donee of power to whom the settlor or donor of power appointment gives such power to be exercised in the case of a special power in favor of a limited class, such as members of a family, or in the case of a general power in favor of anyone, including the donee himself. So we have that information clear now. It's clear. Created a trust, power of appointment. Okay. So now, if that's the case, what are we doing here? Why is all these things going on without the authorization of the mortgagor, the trustor, the donor, the settlor, right? Yeah. So yeah, we go ahead and after I show you, I'm gonna pull it up too on that one. On this, this is Black's Law. This is Black's Law 5. Okay, there we go. Donatio, a gift, a transfer of the title to property to one who receives it without paying for it. The act by which the owner of a thing voluntarily transfers the title and possession of the same from himself to another person without any consideration. So like we got right here, a gift. So what they're saying is that we gifted this to them. All right, let's go here to donor. Donation lands. Lands granted from the public domain to an individual as a bounty, gift, or donation. Ah, is this what they're doing? Regularly in early Pennsylvania history, lands thus granted to soldiers of the Revolutionary War. Okay, so here we go. Donee, donee beneficiary, donee of power, donor. Definition hasn't changed. The party conferring the power, one who makes a gift, one who creates a trust, he who gives lands or tenements to another entail. In Old English law, he by whom lands were given to another, the party making a donatio. So here's the thing, and we'll finish off with this, is that when you're looking at this situation and you tie it to a deed of trust, right? What's going on right here is what they're saying is that you donated this land or this property. They're not even saying land at this time, but this property, right? Under this power of appointment, right? Under this power of appointment, under this power of appointment, for no consideration. But they're actually putting a number here because if you ask around and see if anybody got a check for the amount the thing was being sold, actually have them go look at the records and see. I got to redact it, but I'm gonna show you some more documents next time and see if they're actually stating in the records that you actually sold them the house, that you actually sold it, that you gave the trustee, the substituted trustee in here, the authorization to sell the house and not give you any money. And the sale was to pay off a debt that actually wasn't attached or encumbered on real property. See, we got to connect the dots. We're gonna connect the dots here. Run it back, run this play back a little bit, get it in your mind, the process of what's taking place. It's a simple game here. Simple game. Let's look up. All right. So if you look right here, there you go. property with respect to which decedent exercises a general power of appointment created on or before the extent of any property with respect to which a general power of appointment created. This is the Power of Appointment Act. See, deals with estate tax. So these words, these verbiages are actually been placed in law through Congress in regards to the relationship of the people and these agencies, these banks, these vendors, these third parties, these servicers. I mean, all the words that we had to go back and play it again. These key words, servicers, what they're actually doing. They're not lenders. Lender at not one point in time did you see in these documents that I read. You didn't even see creditor. All you saw was servicer. So we'll touch on that power of appointment next time. And let's just leave it right there. We stop sharing real quick. Um, yeah, so
Sunday Showcase, made possible by a public service grant from the National Endowment for the Arts and Bristol Myers Company in association with its divisions.
All right. Till the next time.
Peace.